Part 14. Aggravating circumstances. The following are aggravating circumstances. 1. That advantage be taken by the offender of his public position requisites. The offender is a public officer. The commission of the crime would not have been possible without the powers, resources and influence of the office he holds. Essential. Public officer used the influence, prestige or ascendancy which his office gives him as the means by which he realized his purpose. Failure in official is tantamount to abusing of office. Wearing of uniform is immaterial. What matters is the proof that he indeed took advantage of his position to. That the crime be committed in contempt of or with insult to the public authority's requisites. The offender knows that a public authority is present. The public authority is engaged in the exercise of his functions. The public authority is not the victim of the crime. The public authority's presence did not prevent the criminal act. Example. Juan and Pedro are quarreling and the municipal mayor, upon passing by, attempts to stop them. Notwithstanding the intervention and the presence of the mayor, Juan and Pedro continue to quarrel until Juan succeeds in killing Pedro. Person in authority. Public authority who is directly vested with jurisdiction, has the power to govern and execute the laws. Examples of persons in authority: governor, mayor, barangay captain, councilors, government agents, chief of police. Rule not applicable when committed in the presence of a mere agent. Agent. Subordinate public officer charged with the maintenance of public order and protection and security of life and property. Example. Barrio vice lieutenant, barrio councilman. 3. That the act be committed. 1. With insult or in disregard of the respect due to the offended party on account of his a. rank, b. age, c. sex or 2. That it be committed in the dwelling of the offended party, if the latter has not given provocation. Circumstances, rank, age, sex, may be taken into account only in crimes against persons or honor. It cannot be invoked in crimes against property. Rank refers to a high social position or standing by which to determine one's pay and emoluments in any scale of comparison within a position. Age. The circumstance of lack of respect due to age applies in case where the victim is of tender age as well as of old age. Sex refers to the female sex, not to the male sex. Not applicable when the offender acted with passion and obfuscation. There exists a relation between the offender and the victim. But in cases of divorce decrees where there is a direct bearing on their child, it is applicable. The condition of being a woman is indispensable in the commission of the crime. X. Parricide, rape, abduction, requisite of disregard to rank, age, or sex. Crimes must be against the victim's person or his honor. There is deliberate intent to offend or insult the respect due to the victim's rank, age, or sex. Disregard to rank, age, or sex is absorbed by treachery or abuse of strength. Dwelling must be a building or structure exclusively used for rest and comfort. Combination house and store not included. May be temporary as in the case of guests in a house or bedspacers. Basis for this is the sanctity of privacy the law accords to human abode. Dwelling includes dependencies, the foot of the staircase and the enclosure under the house. Elements of the aggravating circumstance of dwelling. Crime occurred in the dwelling of the victim. No provocation on the part of the victim. Requisites for provocation. All must concur. Given by the owner of the dwelling sufficient immediate to the commission of the crime. When dwelling may and may not be considered. When it may be considered. When it may not be considered. Although the offender fired the shot from outside the house, as long as his victim was inside. Even if the killing took place outside the dwelling, so long as the commission began inside the dwelling. When adultery is committed in the dwelling of the husband, even if it is also the dwelling of the wife, it is still aggravating because she and her paramour committed a grave offense to the head of the house in robbery with violence against persons, robbery with homicide, abduction, or illegal detention. If the offended party has given provocation. If both the offender and the offended party are occupants of the same dwelling in robbery with force upon things, it is inherent for that the act be committed with 1. Abuse of confidence or 2. Obvious ungratefulness. Requisites of abuse of confidence. Requisite of obvious ungratefulness. A. Offended party has trusted the offender. B. Offender abused such trust. C. Abuse of confidence facilitated the commission of the crime. A. Ungratefulness must be obvious, that is, there must be something which the offender should owe the victim a debt of gratitude for. Note. Robbery or theft committed by a visitor in the house of the offended party is aggravated by obvious ungratefulness. Example. A jealous lover, already determined to kill his sweetheart, invited her for a ride and during that ride, He stabbed her. Abuse of confidence is inherent in malversation qualified theft. Estafa by conversion. Misappropriation qualified seduction. 5. That the crime be committed in the palace of the chief executive, or in his presence, or when public authorities are engaged in the discharge of their duties, or in a place dedicated to religious worship. Requirements of the aggravating circumstance of public office. A polling precinct is a public office during election day. Nature of public office should be taken into account, like a police station which is on duty 24 hours a day. Place of the commission of the felony, par 5. If it is Malacanang Palace or a church, is aggravating, regardless of whether state or official functions are being held. As regards other places where public authorities are engaged in the discharge of their duties, there must be some performance of public functions. The offender must have intention to commit a crime when he entered the place. Requisites for aggravating circumstances for place of worship. The crime occurred in the public office. Public authorities are actually performing their public duties. The crime occurred in a place dedicated to the worship of God. Regardless of religion, offender must have decided to commit the crime when he entered the place of worship. When paragraph 2 and 5 of Article 14 are applicable. Committed in the presence of the chief executive, in the presidential palace or a place of worship, par. 5. Art. 14. Committed in contempt of public authority, par. 2. Art. 14. Public authorities are performing of their duties when the crime is committed. Same when crime is committed in the public office, the officer must be performing his duties, except in the presidential palace outside the office, still performing duty. Public authority may be the offended party. Public authority is not be the offended party. 6a. That the crime be committed, 1. In the nighttime, or 2. In an uninhabited place, 3. By a band, whenever such circumstances may facilitate the commission of the offense. Nighttime, uninhabited place or by a bang. Aggravating when impunity means to prevent the accused being recognized or to secure himself against detection or punishment. Nighttime begins at the end of dusk and ending at dawn. From sunset to sunrise. Uninhabited place. 1. Where there are no houses at all. A place at a considerable distance from town. Where the houses are scattered at a great distance from each other. It facilitated the commission of the crime, especially sought for by the offender to ensure the commission of the crime or for the purpose of impunity. When the offender took the advantage thereof for the purpose of impunity. Commission of the crime must have began and accomplished at nighttime. Commission of the crime must begin and be accomplished in the nighttime when the place of the crime is illuminated by light. Nighttime is not aggravating. Absorbed by treachery. Requisites. The place facilitated the commission or omission of the crime. Deliberately sought and not incidental to the commission or omission of the crime. Taken advantage of for the purpose of impunity. What should be considered here is whether in the place of the commission of the offense, there was a reasonable possibility of the victim receiving some help. 6b. Whenever more than 3 armed malefactors shall have acted together in the commission of an offense, it shall be deemed to have been committed by a band. Requisites. If one of the 4 armed malefactors is a principal by inducement, they do not form a band because it is undoubtedly connoted that he had no direct participation. Band is inherent in robbery committed in band and brigandage. It is not considered in the crime of rape. It has been applied in treason and in robbery with homicide. Facilitated the commission of the crime. Deliberately sought, taken advantage of for the purposes of impunity. There must be 4 or more armed men. 7. That the crime be committed on the occasion of a conflagration, shipwreck, earthquake, epidemic or other calamity or misfortune. Requisites. Committed when there is a calamity or misfortune. Conflagration, shipwreck, epidemic. Offender took advantage of the state of confusion or chaotic condition from such misfortune. Basis. Commission of the crime adds to the suffering by taking advantage of the misfortune. Based on time. Offender must take advantage of the calamity or misfortune. Distinction between paragraphs 7 and 12 of Article 14. Committed during a calamity or misfortune. Committed with the use of wasteful means. Crime is committed during any of the calamities. Crime is committed by using fire, inundation, explosion or other wasteful means. 8. That the crime be committed with the aid of 1. Armed men or 2. Persons who ensure or afford impunity. Based on the means and ways. Requisites. Exceptions. That armed men or persons took part in the commission of the crime, directly or indirectly. That the accused availed himself of their aid or relied upon them when the crime was committed. When both the attacking party and the party attacked were equally armed. Not present when the accused as well as those who cooperated with him in the commission of the crime acted under the same plan and for the same purpose. casual presence, or when the offender did not avail himself of any of their aid nor did not knowingly count upon their assistance in the commission of the crime with the aid of armed men. By a band. Present even if one of the offenders merely relied on their aid. Actual aid is not necessary requires more than 3 armed malefactors who all acted together in the commission of an offense. If there are more than 3 armed men, aid of armed men is absorbed in the employment of a band. 9. That the accused is a recidivist. Recidivist. One who at the time of his trial for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title of the RPC basis. Greater perversity of the offender is shown by his inclination to commit crimes requisites. What is controlling is the time of the trial, not the time of the commission of the offense. At the time of the trial means from the arraignment until after sentence is announced by the judge in open court. When does judgment become final? Rules of court. Example of crimes embraced in the same title of the RPCQ. The accused was prosecuted and tried for theft, robbery and estafa. Judgments were read on the same day. Is he a recidivist? Offender is on trial for an offense he was previously convicted by final judgment of another crime that both the first and the second offenses are embraced in the same title of the RPC. The offender is convicted of the new offense after the lapse of a period for perfecting an appeal when the sentence has been partially or totally satisfied or served. Defendant has expressly waived in writing his right to appeal. The accused has applied for probation, robbery and theft. Title 10 Homicide and physical injuries, Title 8A. No. Because the judgment in any of the first 2 offenses was not yet final when he was tried for the third offense. Recidivism must be taken into account no matter how many years have intervened between the first and second felonies. Pardon does not obliterate the fact that the accused was a recidivist, but amnesty extinguishes the penalty and its effects. To prove recidivism, it must be alleged in the information and with attached certified copies of the sentences rendered against the accused. Exceptions. If the accused does not object and when he admits in his confession and on the witness stand. 10. That the offender has been previously punished for an offense to which the law attaches an equal or greater penalty or for 2 or more crimes to which it attaches a lighter penalty. Reiteration or habituality. It is essential that the offender be previously punished, that is, he has served sentence. Par. 10 speaks of penalty attached to the offense, not the penalty actually imposed. Reiteration. Recidivism. Necessary that offender shall have served out his sentence for the first sentence enough that final judgment has been rendered in the first offense. Previous and subsequent offenses must not be embraced in the same title of the code. Same title not always an aggravating circumstance, always aggravating. 4 forms of repetition. Habitual delinquency. When a person within a period of 10 years from the date of his release or last conviction of the crimes of serious or less serious physical injuries, robbery, theft, estafa or falsification is found guilty of any of said crimes a third time or oftener. Quasi-recidivism. Any person who shall commit a felony after having been convicted by final judgment, before beginning to serve such sentence, or while serving the same, shall be punished by the maximum period of the penalty prescribed by law for the new felony. Recidivism. Generic reiteration or habituality. Generic multiple recidivism or habitual delinquency. Extraordinary aggravating quasi-recidivism. Special aggravating. 11. That the crime be committed in consideration of a price, reward or promise. Requisites. At least 2 principles. 1. The principle by inducement. 2. The principle by direct participation. The price, reward, or promise should be previous to and in consideration of the commission of the criminal act. Applicable to both principles. 12. That the crime be committed by means of inundation, fire, poison, explosion, stranding a vessel or intentional damage thereto, or derailment of a locomotive, or by use of any other artifice involving great waste or ruin. Requisite. The wasteful means were used by the offender to accomplish a criminal purpose. 13. That the act be committed with evident premeditation. Essence of premeditation. The execution of the criminal act must be preceded by cool thought and reflection upon the resolution to carry out the criminal intent during the space of time sufficient to arrive at a calm judgment. Requisites. Conspiracy generally presupposes premeditation when victim is different from that intended. Premeditation is not aggravating. Although it is not necessary that there is a plan to kill a particular person for premeditation to exist, e.g. plan to kill first 2 persons 1 meets, general attack on a village, for as long as it was planned. The premeditation must be based upon external facts, and must be evident, not merely suspected, indicating deliberate planning. Evident premeditation is inherent in robbery, adultery, theft, estafa, falsification, and etc. The time when the offender determined to commit the crime, an act manifestly indicating that the culprit has clung to his determination a sufficient lapse of time between the determination and execution to allow him to reflect upon the consequences of his act and to allow his conscience to overcome the resolution of his will. 14. That 1. Craft, 2. Fraud, or 3. Disguise be employed. Craft involves intellectual trickery and cunning on the part of the accused. It is employed as a scheme in the execution of the crime, e.g. accused pretended to be members of the constabulary, accused in order to perpetrate rape, used chocolates containing drugs. Fraud involves insidious words or machinations used to induce victim to act in a manner which would enable the offender to carry out his design. As distinguished from craft, which involves acts done in order not to arouse the suspicion of the victim, fraud involves a direct inducement through entrapping or beguiling language or machinations, disguise, resorting to any device to conceal identity. Purpose of concealing identity is a must. Distinction between craft, fraud, and disguise. Craft. Fraud. Disguise. Involves the use of intellectual trickery and cunning to arouse suspicion of the victim. Involves the use of direct inducement by insidious words or machinations. Involves the use of device to conceal identity. Requisite: the offender must have actually taken advantage of craft, fraud, or disguise to facilitate the commission of the crime. Inherent in estafa and falsification. 15. That 1. Advantage be taken of superior strength, or 2. Means be employed to weaken the defense. To purposely use excessive force out of the proportion to the means of defense available to the person attacked. Requisite of means to weaken defense: to weaken the defense. Illustrated in the case where one struggling with another suddenly throws a cloak over the head of his opponent, and while in the said situation, he wounds or kills him. Other means of weakening the defense would be intoxication or disabling through the senses, casting dirt of sand upon another's eyes. Superiority may arise from aggressor's sex, weapon or number as compared to that of the victim, e.g. accused attacked an unarmed girl with a knife. 3 men stabbed to death the female victim. No advantage of superior strength when one who attacks is overcome with passion and obfuscation, or when quarrel arose unexpectedly and the fatal blow was struck while victim and accused were struggling. Versus by a band. Circumstance of abuse of superior strength. What is taken into account is not the number of aggressors nor the fact that they are armed, but their relative physical might. Vis-a-vis the offended party. Means were purposely sought to weaken the defense of the victim to resist the assault. The means used must not totally eliminate possible defense of the victim, otherwise it will fall under treachery. 16. That the act be committed with treachery, alavosia. Treachery. When the offender commits any of the crime against the person, employing means, methods or forms in the execution thereof which tend directly and specially to ensure its execution without risk to himself arising from the defense which the offended party might make. Requisites. Treachery can't be considered when there is no evidence that the accused, prior to the moment of the killing, resolved to commit to crime, or there is no proof that the death of the victim was the result of meditation, calculation or reflection. Examples: victim asleep, half awake or just awakened, victim grappling or being held, stacks from behind. But treachery may exist even if attack is face-to-face, as long as victim was not given any chance to prepare defense, that at the time of the attack, the victim was not in the position to defend himself, that the offender consciously adopted the particular means, method or form of attack employed by him does not exist if the accused gave the deceased chance to prepare, or there was warning given, or that it was preceded by a heated argument. There is always treachery in the killing of child, generally characterized by the deliberate and sudden and unexpected attack of the victim from behind, without any warning and without giving the victim an opportunity to defend himself. Treachery. Abuse of superior strength. Means employed to weaken defense. Means, methods or forms are employed by the offender to make it impossible or hard for the offended party to put any sort of resistance. Offender does not employ means, methods or forms of attack. He only takes advantage of his superior strength means are employed, but it only materially weakens the resisting power of the offended party where there is conspiracy. Treachery is considered against all the offenders. Treachery absorbs abuse of strength, aid of armed men, by a band and means to weaken the defense. 17. That the means be employed or circumstances brought about which add ignominy to the natural effects of the acts. Ignominy is a circumstance pertaining to the moral order, which adds disgrace and obloquy to the material injury caused by the crime. Applicable to crimes against chastity, rape included. Less serious physical injuries, light or grave coercion and murder. Requisites. Examples. Accused embraced and kissed the offended party not out of lust but out of anger in front of many people. Raped in front of the husband. Raped successively by 5 men tend to make the effects of the crime more humiliating. Ignominy not present where the victim was already dead when such acts were committed against his body or person. Crime must be against chastity. Less serious physical injuries, light or grave coercion, and murder. The circumstance made the crime more humiliating and shameful for the victim. 18. That the crime be committed after an unlawful entry. Unlawful entry, when an entrance is effected by a way not intended for the purpose. Meant to effect entrance and not exit. Why aggravating? One who acts, not respecting the walls erected by men to guard their property and provide for their personal safety, shows greater perversity, a greater audacity, and hence the law punishes him with more severity. Example. Rapist gains entrance through the window inherent in. Trespass to dwelling, robbery with force upon things, and robbery with violence or intimidation against persons. 19. That as a means to the commission of the crime, a wall, roof, door or window be broken. Requisites. Applicable only if such acts were done by the offender to effect entrance. Breaking is lawful in the following instances. A wall, roof, window, or door was broken. They were broken to effect entrance. An officer in order to make an arrest may break open a door or window of any building in which the person to be arrested is or is reasonably believed to be. An officer if refused admittance may break open any door or window to execute the search warrant or liberate himself. 20. That the crime be committed, 1. With the aid of persons under 15 years of age, or 2. By means of motor vehicles, airships or other similar means. Reason for number 1. To repress, so far as possible, the frequent practice resorted to by professional criminals to avail themselves of minors taking advantage of their responsibility. Remember that minors are given leniency when they commit a crime. Example. Juan instructed a 14-year-old to climb up the fence and open the gate for him so that he may rob the house. Reason for number 2. To counteract the great facilities found by modern criminals in said means to commit crime and flee and abscond once the same is committed. Necessary that the motor vehicle be an important tool to the consummation of the crime. Bicycles not included. Example. Juan and Pedro, in committing theft, used a truck to haul the appliances from the mansion. 21. That the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. Cruelty. When the culprit enjoys and delights in making his victim suffer slowly and gradually, causing him unnecessary physical pain in the consummation of the criminal act. Cruelty cannot be presumed nor merely inferred from the body of the deceased. Has to be proven. Mere plurality of words do not show cruelty. No cruelty when the other wrong was done after the victim was dead. Requisites. That the injury caused be deliberately increased by causing other wrong. That the other wrong be unnecessary for the execution of the purpose of the offender. Ignominy, cruelty, moral suffering, subjected to humiliation, physical suffering.